Mate, don't overthink it. You can't own the land, sure, but just build the house in her name or in her family's name. It's fine. Everyone does it.
Everyone does say that. It's also one of the most expensive sentences in Philippine expat life. And today we're proving it with the actual law, not the beach bar version. Here's the belief, stated plainly, because it deserves to be stated plainly before we take it apart. If you can't own the land, building on it in your wife's name is a safe workaround, because marriage makes it a shared asset anyway. That belief is doing a lot of load-bearing work in a lot of expat retirement plans, so let's check the paperwork. Article 445 of the Civil Code says whatever is built on land belongs to the owner of the land, not the person who paid for it. If the title is in her name alone and it's her exclusive property, this is the default rule the house falls under. Husbands and wives can't sell property to each other. Full stop. Same rule applies to renting it too. A lease between spouses doesn't count either. So Article 445 says the house belongs to whoever owns the land. Case closed, right? Not quite, because Article 445 is the default, and marriage has its own rulebook that can override it. Here's the twist. If what you build is worth more than the land it sits on, the whole thing, land included, can legally flip to shared ownership. Not a maybe. The law actually says that. But you'd have to prove that in court, years after the relationship that made you want to spend the money is already over.
Hang on, so there's actually a way this works out?
There's a way it can, but you don't want to be relying on a value threshold argument you'd have to prove in court after the relationship's already fallen apart. That's not a plan. That's a lawsuit with a coin flip attached. Run the numbers on what relying on that threshold actually means in practice. Say you spend 2.5 million pesos building your family home on her titled land, and the land itself was only ever worth a few $100,000. On paper, you'd have an argument that the whole property should now be shared. In reality, you're proving fund sources, construction costs, and valuation dates in a Philippine court, years after the relationship that made you willing to spend the money is already over.
Fair enough. Maybe don't just wing it.
Now, flip the numbers because the flip to shared ownership scenario is actually the less common one. Most people aren't building a mansion on a cheap block. They're doing a modest extension or renovation. Say you put 800,000 pesos into the house, and the land itself is worth 600,000. The improvement doesn't clear the land's value. Nowhere close to a flip. In that version, Article 120 defaults back to what it does most of the time. The land stays hers, and the community is owed reimbursement for what was spent. Not ownership, just the money back. And here's the part that matters more than the legal theory. Proving that claim in court still requires the same thing the flip to shared claim needed. Receipts, dates, a paper trail showing where the money came from. Miss that, and owed reimbursement becomes good luck proving it.
So basically, keep the receipts, every receipt.
Every receipt. Two things people ask in the comments every time this topic comes up. Quick answers, both worth knowing before you build anything. It depends on one thing most people never check. Were you both legally free to marry each other? If yes, neither of you already married to someone else, Article 147 kicks in. And it's actually a stronger default than the married version. Property built through joint effort during cohabitation is presumed owned 50-50. No value threshold to clear, no flipper reimbursement test. But if either of you had a legal impediment, one of you still married to someone else, say, Article 148 applies instead, and the presumption disappears. Now you have to prove exactly what you contributed. Dollar for dollar, or you get nothing. It matters less than people think. And here's the part that surprises everyone. If you married without a prenup, the salary or pension you earned during the marriage is already community property under Philippine law, legally both of yours, no matter whose account it sits in. So when you spend your money building on her land, you're usually spending community money, and it's the community that holds the reimbursement claim. The only money that stays genuinely yours is the narrow stuff. An inheritance, a gift, in some cases what you owned before the wedding. Either way, the claim is only as good as the paper trail behind it.
Righto, so talk to an actual lawyer, not just me and a beer.
Exactly that. This doesn't mean don't build. It means the protection has to exist on paper before the money moves. Clear documentation of what was spent and when, a construction agreement naming you as the builder of record, or a registered usufruct or long-term lease structure that survives the relationship on its own terms rather than depending on a courtroom valuation fight. We're building to the strongest version of that answer in video 4. For now, the takeaway is non-negotiable.
Do your due diligence, mate.
Paper first, money second.